Judge, I wanted to approach on a fugitive case. I wanted to see if we could bring him out.
What would you like to do?
Judge, I wanted to approach to see if you would reconsider a fugitive bond.
Okay.
Yeah.
Well, good morning, Mr. Jackson. So, Amy, we spoke about this last week.
Yes, Judge.
I denied him a bond last week.
Yes.
Has anything changed?
No, Judge, it's the last thing for no bond.
Tell me, I don't even remember. What does he want it for?
He's wanted from Broomfield County, Colorado for failure to appear for burglary.
Quick pause here. Skipping a court date is a huge red flag in the justice system. Judges don't just look at the charge, they look at reliability. And failing to appear screams unreliability. What do you think? Should skipping one court date permanently kill someone's chances at bond?
It was issued in October of 2023. He's also here in Harris County for evading under vehicles. He also has other criminal history that we can go into, but it would need to be offline stream.
Okay, I remember that. Okay.
Judge, yes. First, criminal history. I don't know how much we should go into that. We are here.
Don't go into anything that's,
No, just
We're going to-
it's not something I want to go into anyways. I don't think it's relevant to whether or not he's gonna turn himself into Colorado or not. I think if we focus on that, the argument is that he would like an opportunity to go turn himself into Colorado for this pending case. He hasn't been found guilty out there. He's presumed innocent. He would like the opportunity to go turn himself in. He hasn't messed up in your court before. He hasn't been given that opportunity before. And he is not asking for a PR bond. He's asking for a bond sufficient enough to guarantee that he will go turn himself in over there. He has family members here in court today showing their support for him. He's got 3 family members. After talking with them, they are inclined to help him make a bond as well. They understand the risks. He understands the risks if he doesn't turn himself in over there. He understands the complications of having to meet his court date deadlines. And so we are just asking for you to consider giving him a sufficient bond to go turn himself in.
who's here? Mom?
Judge, we have his sister, stand up, please. We have his sister-in-law, his girlfriend, and his cousin. Sister-in-law, and girlfriend.
Thank you for coming, God. Really, I appreciate you coming. You're welcome to come up if you want.
And these are the family members that would be responsible for helping him post the bond. They would be posting the bond for him, and they understand the risks involved.
Sure. Hi.
Hi.
Thank you for coming. Thank you for coming. Thank you for coming. You know, and I told this to Mr. Jackson about a week and a half ago. There are several things that I look at when I give someone a bond. One of the things I look at is their prior criminal history, what they have done, how old they are, and whether they've left a wake of just destruction in their path. Mr. Jackson is very young. Right? He's what, 20, 22? And in the short time that he's been alive, he's managed to rack up a ton of cases. Just here in Harris County, an evading that was dismissed in 2021, he picked up a felony theft in 24, an evading arrest in 24. He has a fugitive case out of another jurisdiction of another state, and now he picked up here 2 weeks ago another evading arrest. So the common theme that we have here is I'm going to take off and I'm going to try to evade. That's the common theme that we have. And the 2 things that I don't want are, number 1, I don't want him to pick up another case. And most importantly, I don't want my public to be in danger. These are the things that I consider. What does he want it for out of state?
Failure to appear for burglary.
And now he has another burglary in another state for failure to appear for that. At what point do we say when? So my point is that the problem is that if I give him a bond and he just takes off, all you guys are going to lose out on all that money. And what happens if he picks up another charge? So these are the things that I consider, and this is why I denied him a bond the first time, is because what the common theme that we have here is that in the short time that he's been an adult, there's a ton of evading and flight cases. That's why I didn't want to give him a bond. Because in my opinion, he already has 3 flight cases. Do we need a 4th? And that's what scares me. Carter.
Judge, considering all that, considering his family's here, we would be asking for an amount that ensures his attendance in Colorado. I think by putting an amount on his case, it would ensure that he hasn't had this opportunity before. He hasn't had a risk of losing money before. This risk would ensure that he does what's right and turns himself in over there.
But he has, though. You know, he has. He got out in Colorado, failed to appear on that. He's constantly trying to evade, you know, here as well. It's a constant thing. And I can't continue to say, okay, it's okay for you to do this. La, da, 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 da. It's not okay. The bill comes due. Do you understand? At 22, you have all these cases? Life is hard enough as a young black man in today's society as it is. And now with all this, really? You want a pat on the back for all this? You want me to just, no. Now the bill comes due.
Judge, if I may, respectfully, one of the things that I wanted to do was look into the Colorado system to see if it was actually a failure to appear or if this was a sort of like a to-be warrant here in Texas. I wasn't able to log into that system over there, and I don't think we can make the distinction on whether or not it was a to-be warrant based on the documents that have been filed, or if this is one of those situations where he missed a court date.
Regardless,
Okay.
all we have are someone constantly trying to evade capture. They're trying to evade police one way or the other. I have a feeling if I let him out, the same thing's going to happen, you know, and I don't want that to happen. I don't want you to pick up a 4th case, 5th case. I certainly don't want anyone to be injured. And that's it. At 22, all this baggage, it's not going to happen, man. The bill comes due. I certainly appreciate you guys coming. I know that you've taken a lot out to be here today. It's just too much baggage. I'm sorry. Okay. Thanks, guys.
Thank you, Judge. Thank you for your consideration.
Of course.
On the docket Monday, and
It was on the docket.
yeah, it was on the docket Monday.
Okay.
On the docket today. You want case number?
Sure.
It's 2551572. We originally, I was assigned to represent him on February the 17th, and he had already executed a waiver. He had a local case that's pending in court number 2, which the court granted him a PR bond on February the 14th.
Uh-oh. You guys notified the remaining jurisdiction?
So this one,
Well, this is kind of unusual.
Okay.
We were reset until Monday because that would have been the 14-day time period. For some odd reason, even though the bond, which I want to tender to you, local case was signed by the judge, defendant, and everybody on February the 14th. And it was entered on February the 15th. For some odd reason, the sheriff's office didn't
Okay, just the last one.
look to hold off of him for the local case until February the 28th.
Julie Soldano, it was,
Are you saying they didn't see the release of the hold until the 28th?
no, it wasn't made until the 28th, but it wasn't remitted to the sheriff's office until March 3rd, according to Greg. So it was set on, bond was set on the 21st, but it wasn't made until the 28th, remitted on the 3rd.
Oh.
For the local case, not for the fugitive case. Sorry, for
The local
the,
case, bond was signed by the defendant, the magistrate,
On
and
the February 14th.
by February.
So the hold, so the 14 days starts running that day.
That's what I said.
I don't have the.
This is Christie, she's the attorney representing the local case. In court number 2.
Yes. And I think there was an issue with the spin numbers too, but I don't know if that was.
There was a spin consolidation, that was a separate
Oh, okay.
hold. So that would have held regardless, but I'm gonna raise expertise on that part, because I was asking most of the questions regarding that.
Where's he won from anyways? Is somewhere to,
Oklahoma,
Oklahoma for,
Ottawa,
Miami.
First degree robbery, though.
yeah.
Ottawa County.
I mean, unless you have like a pre-signed waiver or, you know,
This one's
carries a life term.
first degree robbery, I don't know, I can do a quick check though.
Here's the drama. The defendant's future is now tangled in clerical errors. A paperwork slip-up could mean days behind bars. Imagine losing your freedom because someone in an office didn't file a form on time. Should the system bend for mistakes like this, or is that just the cost of playing the game?
I mean, he shouldn't be held to pay for the mistake of someone else.
Let's see, that one is not less than 10 years, so 10 is the floor. What is,
I'm with you, Carl. I'm not gonna let him pay for someone else's mistake, you know?
So the fugitive is dismissed.
Well, I don't know. If he decides not to, then I'll just give him a PR bond.
Okay.
well, no, I mean, in terms of, so,
Or how do you want to handle it, Dave?
hold on. Actually, the other thing I tasked Amy is to contact the demanding jurisdiction to figure out when they would be able to come.
I'm still waiting on a response from the defendant.
I mean, because we still have a couple days regardless, right?
Right.
Well, he's
So,
in court today on the misdemeanor, which was reset until March the 18th, 17th.
But you, yeah.
Regardless, though, they still have a couple days for the 14 days, or is the 14 day today?
The 14 days would have been up March 3rd.
if you're going all the way back to the 15th, sure, but I contend that he
It's
did.
over.
I contend that he didn't make it until the 28th, because there's still the spin consolidation even before the leasehold, so.
Now, he made the bond on February the 14th. The sheriff's office, that's on them. They didn't do whatever they were supposed to do until March the 3rd or February 28th or whatever
Well,
dates
They
are
didn't
relevant.
do anything wrong, they never got the information, so they didn't do anything wrong because they didn't get the paper.
So is the district clerk's office then.
They're right. He's right there. So it's the one that we talked about regarding the hold, figuring out what the hold issue was, but I don't know to the contents of it, just that the sheriff's office didn't have it. So,
Regardless, I can't,
yeah.
I'm not gonna let him pay for someone else's mistake. Whoever, it doesn't matter who it is.
No, but I'm saying, even assuming going back for the dates that he had after he made the bond, is there was still a spins consolidation hold, which is different, because that's not case specific, but I don't know the answer to
Here,
that.
no, right.
He's in court number
Court
two.
two.
I'd like to talk to him.
Can the bailiff bring him up
Because
to?
what I'd like to do is admonish him to let him know that
He's very confused.
we're gonna release you, but that warrant is out there and it's always gonna be out there and they can go and get a hold here tomorrow or later today.
Does live there. He was just here for.
So if you release him on bond, Judge, does he have 14 days to go up there to get the?
No, he's
No.
released. He can do it.
Do you need to run down to
That
court too?
warrant will always be there.
Okay, you want to come, you want to,
He could theoretically call them and they could issue a new one right now before he's even released.
Sorry, so, because in the condition that he is released, Judge, you typically give them an opportunity to respond in lieu of them not coming. If it's a matter of just, of the court admonishing,
I was gonna admonish the defendant and go, look, you know, I'm giving you a PR bond, right? Because there's a mix-up.
but for the PR bond, that would necessitate a reset for a future date, which is why I'm bringing up the question. If it's an admonishment for him to return, it still needs a set date for
Yeah,
robbery.
that's right.
that's what I was asking.
But that being said, I'm double checking because it's a floor of 10 for first degree robbery. If it's life, then he is not eligible, which is what I'm still checking.
When someone gets a charge and it carries a term of life, I'm not allowed to give them a bond, no matter what.
True.
So I can't imagine on a first degree robbery it's gonna be.
I mean, for our first degrees, we have 5 to life, so assuming that Oklahoma's similar, then
Well, that's
that's
true.
why I'm checking. I don't know. Yeah, well, I mean.
Well, there's different degrees of robbery in the state of Texas.
This one's first degree though. This one it says on the teletype. But AI, Google AI, however reliable that is, does say life, but let me double check though. I don't want to misspeak.
You'll sign in just a minute.
Solicitation, murder, manslaughter. robbery in the first degree, a felony. Sorry, now with Oklahoma Penal Code. So
You speak Okie?
not well. Not well.
I don't think that, they can't read and write up there anyway.
208.
Okay, go ahead and sign, please.
You be talking about sinners.
Robbery, 2 or more persons, a felony. Attempted robbery with
10 years.
I'm sorry?
I got 10 years, but I don't know, it
No,
could be
it's,
wrong too.
well, not less than 10 years, but it doesn't show the maximum. I don't think it cites a maximum,
Just a minimum?
just a minimum. Well, some states just do that where there's just a minimum and obviously there's no ceiling. With the exception of,
Yeah, I see what you said. There's no max, which is really weird, right? It's like,
it is, but it's not the first penal code that I've seen that does it that way. But I interpret that as life in prison. If you want me to double check, I can call the ADs there if they interpret that in life in prison. If they do, obviously it's involved.
how can you possibly interpret that as a life sentence?
Oh, like I said, I can call the DA's office there and double check. That's why I want to, if I may have a few minutes to stand down, I can call the DA's office up there. I'll do that right now.
Judge, did you?
Any way you want it, do you want him up here, Judge? One way or another?
Start picking a jury at 11 is what I was told in court too.
Is there any way we could get him, you think?
I was,
Deputy, he's in court 8. Can we get Roderick Bolton? He's down in court number 2.
Is it possible to get someone who's in court too? Please, Bolton. Do you mind giving him the cause number and maybe he can?
Judge.
Morning, Mr. Bolton. I wanted to bring you here because there's a lot of things that you need to understand what's going on. You're wanted out of another state, Oklahoma, specifically for first-degree robbery.
Yes, sir.
And there are certain times that I can give someone a bond, and then there are certain times that I cannot give someone a bond.
Yes, sir.
Typically, I can in almost all situations, except for number one, where someone signs what's called a pre-signed waiver. Let's say you get on probation in Oklahoma for a case, right?
Yes, sir.
One of the conditions that you sign, you say, I agree to waive extradition in the event I ever become a fugitive. So if you take off, you become a fugitive, you can't try to get a bond because you've already, in essence, waived by getting onto the probation.
Yes, sir.
The other instance is when there is a charge where it carries a term of life
Yes,
in
sir.
prison.
This one's a first degree robbery, Your Honor. It has a minimum 10 years prison up to life in prison. So because the punishment range extends to life in prison is, it states contention that he is ineligible for bond.
Response, do you have any?
The response is the statute that you read has no ceiling. And it doesn't state, the
Let's do
statute
this.
doesn't state the ceiling's
I don't
life.
want to do something wrong, so I'm not going to set a bond now. Do, any kind of research that you may. If you find something different, let me know. I'm all ears. If you find something contrary to that, I'm always willing to listen. And then if so, I will. The problem is in your cases, typically we give other jurisdictions 14 days to come get you. In this case, someone somewhere dropped the ball where they didn't give sheriff's office notice to call Oklahoma to say, hey man, come get him. So Oklahoma really never even knew to come get you, right?
That's correct.
Till Monday, 3rd.
So the 14 days ran on the 3rd, now it's the 5th. So that's why there was this little snafu where I was going to give you a bond today and I was ready to until they said that this now carries a term of life. So I can't. That's where we're at. So I'll have them do research to see if there's something different. If there is, then I'm all ears and we'll go from there. In the interim, we don't want you to just sit there and languish. So Mr. Kim is going to talk to Oklahoma to see how fast they can get here to come pick you up to take you back. You need to understand one more thing is that you were on bond for a case in here. You need to stay in contact with your lawyer here because if you don't and you get up to Oklahoma and for some reason the bond gets forfeited or revoked here, the situation you're in here, it's going to happen over there in Oklahoma. So you'll be back over there, but then Harris County is going to get a hold on you here. So make sure you stay in contact with the lawyer so they know exactly what's going on at all times so as to not something bad happen to your boss. Do you understand? I wanted to bring you here just to give you a heads up so you know, I mean, these are your cases. You need to know what's going on. It's only fair. So, so if you have any questions, I'll direct you to your lawyers here and they can answer anything that you may have.
So Amy just said, just talk to them. They can be here by the 17th, so we'll meet the deadline by the 18th. So they will be here the day before the next court setting here.
Okay? They'll be here the 17th to come get you.
And there it is, the shift into a brand new case. From fugitive bonds to family violence, this courtroom swings fast. Which case do you think is tougher to judge, the runaway fugitive, or the family dispute that could tear a household apart?
Thank you, Judge.
So just, I guess, whatever you can on your case there, because
Right,
it could impact. Yeah,
okay.
Okay. Thank you, Judge.
thanks, Carl.
If I find anything different, I'll let you know.
Just let me know. I'm all ears, always. Good morning, Mr. Garrett. Sir, you're charged with terroristic threat of a family or a household member. That allegation kicks it up to a Class A misdemeanor, so you are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On February 25th, 2025, the officers were dispatched to a residence in Harris County, Texas for a disturbance with an unknown weapon at approximately 5:49 p.m. And upon arrival, the officers met with the complainant, who stated she is the mother of the defendant and they live together. The complainant stated that day her healthcare provider came to her residence to help her as she is disabled. And the complainant stated the defendant was in his room playing loud music, and the complainant asked the defendant to turn it down while her provider was there. The defendant did turn it down, and as soon as her provider left, he turned the music back up. The complainant requested the defendant turn the music down again, and a verbal altercation ensued over the music and money, and the defendant started to rip up family photos. The complainant tried to stop the defendant, but the defendant grabbed the complainant by her arms and pinned her against the wall. The complainant stated she did not feel pain, but that the defendant said to the complainant that if she continued to touch him, that the defendant would break the complainant's jaw. The defendant was on the scene and refused to speak to officers.
Okay. Mr. Garrett, I'm going to find that there's sufficient probable cause to go forward with your case. Do we know what mom wants?
See if a rip was attempted, Your Honor, and unsuccessful.
We have a call scheduled later this afternoon. She won't be available until afternoon.
This is a problem. I normally order in these types of cases that you're not to go back to his place. So if you don't have anywhere else to go to, what happens? You have to be careful in these situations, Mr. Garrett. So let's do this. How old are you, sir? 20. I'm going to give you a lawyer today. I want you to talk to the lawyer so we can figure something out. I don't want to put you out on the street, but I got to protect every person here. You understand? So I'm ordering you as a condition of your bond not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're using anything, I will revoke your bond, put you in jail. Do you understand? You're not to be in possession of weapons as well. And you're not to have any threatening or harassing contact with mom. If I find that you do, likewise. You got out of jail because we gave you a free bond. What happens if we put it at 5 to 10,000? If you don't have anyone to bond you out, you'll be stuck like Chuck in there until this thing's over with. And it takes a long time just to get a 911 tape. You understand? So I'm going to have you sign a reset. Let me have you take your seat in the jury box. I'm going to find your lawyer and then we'll go to it. Come on.
Is that-
Garrett,
Yes, sir.
terroristic threat
Right.
against allegedly mom.
Okay.
Could have been an assault. Not.
My aunt had, she'd be my uncle.
No, but according to what I was reading here, you know, he's lucky that it's not filed as an assault. And the thing is that do we let him go home? What's going to happen? No, because come up, Mr. Garrett. When I have these types of cases, normally I don't let the people go back. Because, or do you want to talk first and then you come?
Yes, sir. Can we step down?
Yeah. So the first thing I told Mr. Garrett is that he's not to use any illegal substances and that you're going to get tested. I want you to know now that I will test you 40 days to 45 days from today. If I find that you're using anything illegal, including THC, I will revoke your bond and put you in jail. Do you understand?
Yes, sir.
Okay. When I have these types of cases, I typically prevent the person here to have any contact with or to go back to the house where the complaining witness lives. Does he currently live there now?
He does, Judge.
It's going to be a problem. So how, because what the last thing I want, Mr. Garrett, are more words to exchange and you end up with another case because there's now bad blood between you two. That's the last thing I want. So how do we prevent that from happening, Abel? What do we do?
Judge, I request that the court order no harmful injurious contact with the CW. Based on my reading of the case, it doesn't appear that a no contact order is required or warranted at this point, Judge.
From what I read, it could have been an assault that you could have been charged with in addition to this case here. What do you think? Say,
Our state would request, I mean, we've got a call scheduled to complain at noon. State would request some sort of cooling off periods. There would be no contact order. Very dangerous cases. We usually have very cooling off periods since these are fresh charges.
do we put him on the street though? Because essentially that's what's going to happen. He's 22, right?
Yes, sir.
Yeah.
We can also, I mean, hold off till it's just at noon.
Yeah.
If it would be okay with the court, I know it's be later in the day till noon.
Judge, she's at the hospital. I don't know if she let y'all know that that's where she was.
No, she-
She's at the hospital right now, so that's,
Why?
I didn't ask her.
How do you know that she's in the hospital? Figure out, I guess.
Let's reapproach
So
this afternoon.
are you done? Do you have anything else to do?
The reason I came back.
So, for now, let's do this. I'm going to allow him to go back. You guys get a hold of her. If for some reason she says that she doesn't want him back, let me know. I'll get in contact with him and then I'm going to modify the order so that he can't go back to the house. I'm going to assume because of the relationship, right? And I don't want to put him on the street, but if she doesn't want him back, then obviously I want to follow the complaining witness's wishes. That's what I always want to do. I don't know if she wants you back. If she does, okay. If she doesn't, but be that as it may, self-control. Because I find that you are mistreating this person, threatening, abusive in any way. And I'm going to tell you now that conduct in and of itself can violate this court order. If I go like this, is that threatening or harassing? It most certainly is, and it'll land your ass in jail. You think it's funny?
No,
Just wait till you get behind and you'll see. I'm trying to tell you that exercise self-control because I will protect every person. And if I find that you become an issue to her, it's not going to go well for you. I will test you 40 days from today. If you test positive for dope, it's not going to go well for you. Do you understand?
Yes, sir.
Okay.
Your Honor, I will let the defendant has been smirking some time.
I know.
The state's concerned that he's not taking this seriously. Sorry, Your Honor. It's just-
I get it. I get it. Well, he's on notice of what he can and can't do. And the problem is that there are a lot of people on a very fixed income. And I'm going to tell you now that the complaining witness in this case, she's on a fixed income. So you go to jail with a $5,000 to $10,000 bond. Just please admonish him accordingly. Okay.